Welcome to Smart Branding, a podcast dedicated to branding, naming, and domain names. I'm Tatiana Bonneau, and with my guests, we try to help you create and grow strong, memorable, and meaningful brands online. I believe time is one of our most precious assets, and so I want to thank you in advance if you decide to spend the next 30 minutes with us. I promise to do my best to make those worth it. Let's go!
So I have some preliminary maybe caveats to the comments that I can give today, but happy to let you sort of take it away and ask whatever questions that you have. So maybe I'll just start very quickly just about the little caveats that I have. So I'm an attorney. I'm in the United States. I practice trademark, copyright, advertising law. Anything I say really today are just general comments about this area of the law. So anyone who listens to this later, or, downloads the transcript or whatever the case may be, you should know that this area of the law is incredibly subjective. You should always speak to an attorney about your specific fact pattern. I have to say that, unless we've engaged in engagement letter, I'm not your attorney. We don't have any sort of attorney-client relationship. I'm just here today on the podcast sharing sort of general comments and thoughts about branding. I'm obviously coming at this from a U.S. perspective. I think there's a lot of the principles that would apply in the U.S. likely apply outside of the U.S. too in many ways, but you should never assume that the law in one jurisdiction is going to be the same in another jurisdiction. So just to be clear from a legal front, I'm just chatting today.
That's good. I'm kind of imagining you now having to do that anywhere you go with your job.
I should have like a little card maybe, and I could just hold it up to the screen.
Yeah.
And,
that's good.
So that's all. With that out of the way, go for it.
Okay. Yeah. So I've been doing some coaching lately for speaking and all those sorts of things, and I liked very much. Today I was listening to one course, and they were saying you should always try to explain things as if you're talking to like a 3-year-old. And reason being that, and I caught myself, I was like, I do that all the time, because when you're passionate about something and you know your topic, you get into a conversation and you start like talking about it, and you completely forget that the person on the other side may have zero idea, like their level of knowledge and understanding on that topic is probably likely not yours. So I wanted to start with, like, if you can tell me, as if you're explaining it to a 3-year-old, what do you do?
Yeah, sure. And that's actually pretty ezy for me because I have a 3-year-old. So I spend most of my day talking in those terms. No, so what I do, so like I said, I'm an attorney, and I basically have 2 different fronts that I deal with. I deal with the prosecution side of things, and I deal with the litigation side of things. Which I know prosecution sounds like it's a litigious term, but it's really not in this industry. It's maybe a more apt word would be corporate. So about half my day I spend clearing brands. So a brand team will come to me with, I have 5 choices or 10 choices of different things that we want to call this new product, or we have a new tagline that we want to launch. Which one's the most less risk adverse or most risk adverse option. And we'll maybe pick a handful of those. We'll run clearance searches on them. So I'm looking to see what other rights are out there in the space. And then assuming we get comfortable with a brand or a tagline, I'll take that and I'll file a trademark application for it to get protection. And then I'll push that trademark through, hopefully to eventually obtain a registration. That's on the trademark side. Copyright side, very similar. And advertising side also very similar. I'm looking at maybe a video, and maybe there's a third-party brand in the background or something, and what's our risk look like. So that's half my day, and then the other half of the time I spend is litigating. And so maybe we already have a registration and we're going out and we're sending a party a demand letter because they've adopted something that's too close to our name, or we've received the demand letter and I'm responding, or I'm in court, fighting for trademark rights, filing motions, attending hearings, things like that. So that's basically my breakdown. That's a very high level of it. I think, maybe I should have started and backed up to say that there are, when people hear, so I do intellectual property law, and when people hear, oh, you do IP law, people use the terms very interchangeably, though they are not interchangeable in terms of the different buckets of goods that of categories you have. So you've got copyrights as a very distinct area of the law, separate and apart from trademarks, which is a very distinct area of the law, separate and apart from patents, which is a very distinct area of the law. In a copyright realm, we're worried about original works of authorship. We want to encourage people to create content, and that the protections that attach to that and the process for that is different. In the United States, there's the United States Copyright Office. It's completely different from the United States Patent and Trademark Office. The process for getting a copyright registration is different, and the laws that govern it are completely different. Patent law, we're worried about protecting novel inventions. We want, people to create new things that are going to benefit society, and we want to carve out, mini monopolies for them to be able to sell whatever products they've been able to patent for X period of time, which is different than trademarks. And I don't do the patent stuff, so I'm not a patent attorney. I only do the copyrights and the trademarks. And then the trademarks, the last bucket, that's, you encounter trademarks every day. Those are the brands that you see around you. They are source identifiers for particular goods and services. So that when you go to the store, we're in trademarks, we're worried about protecting. Well, there's different theories, but a prevailing theory is that we're worried about protecting the public. We're worried about protecting consumers. And there's value in knowing that when you go to the store, Pepsi is going to taste like Pepsi. The same bottle that you buy here is going to taste like the same bottle that you bought in a vending machine. It's a consistent quality that you can know and expect. And there's value in that. And if somebody comes along and they make a Pepsi product that's not genuine Pepsi, it doesn't emanate from the Pepsi company, then that's a problem, because then you're not going to get that consistent result. And so we want to protect the consumers from being confused about the affiliation or sponsorship or endorsement of the real Pepsi company to that product. So that's maybe that last part was too much for what my 3-year-old might be able to handle, but the beginning part wasn't. The high level.
No,
in there.
I liked it. No, I actually, literally the last part as you were saying it, I'm like, oh, I haven't thought about it that way, because when people talk about trademarks, copyrights, we often have that image of those evil corporations that want to make more money. And the way you're putting it is, no, it's to protect the customer. And that's something that is very different. You're like, oh yeah, that makes sense. That's a good thing. And I mean, you're using the Pepsi example, but it can be anything. Like it can be medications or like toys that your kids play with. And yeah, that's a very different perspective.
Yes. And in fact, the legal standard for trademark infringement is a quote unquote likelihood of consumer confusion. That's the test. And of course, only lawyers could come up with that test because it's so subjective. But what that means, there's different factors that a court could look at, but what they're looking at is, visual similarities between the trademarks. They're looking at, are the goods and services overlapping? Are they similar? Are they related in some way? And are the target consumers the same? There's different factors. The court can look at anything, but generally, if you're checking those 3 boxes, same target consumers, same goods and services, visually similar, phonetically similar trademarks, you're running into the realm of trademark infringement. And that's because if you do those 3 things, most of the time, you're going to have a likelihood of consumer confusion. You're going to cause consumers to be confused. It's going to hurt consumers in the marketplace, and you can't hurt consumers.
So that's a 3 years old can get that. You can't hurt consumers.
Yeah.
There you go.
That's it. That's all you need to know. I mean, case closed. Like I've got books on trademark law behind me that I could have summed it up in like one line and we'd have been done.
Good. Cool stuff. All right. So when we're talking, because I'm on the naming, branding, and domain name side of it, and with the domain names from where I stand, what I see often is businesses or business owners come to think about domain names. Usually, I often get asked like, "What's the biggest mistake when it comes to domain names?" And I mean, I can probably make a list, but the one I would say is most common is not thinking about it early enough. And I guess my question is, when is the right time to think about trademarks and copyrights? And usually when people come up with ideas or start a business, I don't think many, at least small to medium businesses, think about those things initially. So when is the right time?
Yeah, immediately, really, because the sooner the better. Trademark law, just like it's a property law. So like other property law, first in time, first in right. That's a just general principle. So if you go to the grocery store, customers will just sort of ordinarily form a straight line, right? You know, the person in front of you is ahead of you, the person behind you is behind you. Trademark law is exactly the same way. So somebody who is ahead of you, they're first in time, they are first in right, they're going to check out before you. They have better rights. Same with trademarks. So you want to think about it early in the process, because you can file a trademark application that could put you earlier in the line. You know, that's like having maybe my 3-year-old to go stand in line and say, stand there. I'm going to go get milk. I've reserved my spot. I've reserved my spot in line. She's too little to do that, but you get the idea. You could have somebody stand in line.
Yeah.
And that is fine. That's sort of the equivalent of filing a trademark application. You may not have launched the business yet, but you have a good faith basis that you're going to be checking out soon, that you're going to be in business soon. And so you want to reserve that spot. So you should think about it early. The mistake that I see quite often is that people they'll do two things. They'll form a company, they'll register their company with the state, and they'll go to a place like Google Domains. They'll look for a .com variation because everybody still wants it. And they'll register a .com name. So they'll register the .com name, they'll get social media for that name, and they'll register with the state. And they'll think, I'm all set, good to go. And that is where they're dead wrong, because that does not give you trademark rights. Registering the business under the name does not give you trademark rights. I think a lot of people find that confusing. Registering a domain name does not give you trademark rights. What gives you trademark rights is filing a trademark application with your relevant jurisdiction, or, and at least in the United States, selling goods and services under the trademark. That's how you get trademark rights, is you have to be engaged in commerce. So if you're not selling goods and services right now and you don't have a trademark application, just because you registered xyz.com and just because you formed XYZ Inc. does not mean you own XYZ. Somebody else could launch after you incorporated, and have better rights in the name. And in fact, could even prevent you from using that .com domain. So that's the mistake that I see quite often. And it's sort of an understandable mistake, because you think, I've done all those things with my brand. Like, I don't understand. I got the .com like I was supposed to. I did all this stuff. But if you're not filing a trademark application and you're not selling goods and services under the mark, then you are not gaining trademark rights. So that's point one. And so what should you do? The first thing you should do really is clear the name, pick a name, conceive one in concept, run a clearance for it to see if it's available, check to see if the .com domain name's available. And if it is, one that you could register for like $12 a year or something, I'd just snag that immediately. If not, then you want to consider, can you acquire that domain name? Can you buy it from somebody else? But before you even start that process, you'd be better off seeking protection for the trademark, because I have had situations where people spent a lot of money on a domain name, 6+ figures, and only to find out that it conflicts with another brand.
Yeah, I think I have a question on that, actually. because obviously we get that very often, because you have like generic dictionary words, then you have descriptive words. Like I'm very close to the level of your 3-year-old on that. So for example, like Apple has a trademark on computers and phones, etc., a lot of things.
I've
But
never heard of them.
if they were no, if you know that brand,
Apple, yeah, there it is.
But they would not be able to do that if they were to sell like literal apples. Am I correct?
Yeah. Yes, you are. Yes, you are correct with that. So I can explain that a little bit too, and exactly how that works. So take you on a little ride called the spectrum of distinctiveness. And I didn't make this up. This is something that just exists. And again, only lawyers would come up with this, but this is the law. And so all trademarks will sit somewhere on a spectrum of what's called distinctiveness, which is just really how unique the name is in relation to the goods or services that you sell. So all trademark rights, as just a general matter, tie only to specific goods and services. Now you could get to a point where your mark is famous and maybe it ties into other goods and services that you don't sell because it's famous. But that's very few brands that fall into that category. It's a whole other podcast. For purposes of this, let's stick to the basics. Your trademark is falling somewhere on the spectrum of distinctiveness, and it's only in relation to the goods and services that you sell. So the different categories that are on the spectrum are generic trademarks, and that would be like the one that you had picked out, Apple, in connection with the sale of apples. You sell apples, it's generic for what you're doing. It's not a source, it doesn't function as a source identifier. When consumers, so we're going back to consumers, when consumers see Apple, in connection with the sale of apples, they're thinking about the product, not the brand. Those trademarks are generally never protectable. You don't get trademark rights for generic marks. You can't. It's not fair that you could stop competitors from calling their thing what it is. The second category is called merely descriptive trademarks, and that might be, running with your Apple example, apple juice in connection with the sale of juice. It's not generic because it's not the genre of what it is that you're selling, but it describes immediately a quality, characteristic, or feature of the good. It's apple flavored juice. Those trademarks also are not inherently distinctive. They fall on the wrong side of that spectrum of distinctiveness line. So they also are not generally protectable, absent a showing of secondary meaning. And so what that means is, if you have been substantially exclusively selling apple juice under the name apple juice for a period of generally 5 or more years in the US, you would be entitled to a showing of acquired distinctiveness, which means that you've been using it because you've been using it for so long now. Consumers have stopped seeing it as that descriptive term and have started to see it as a brand for the good or service that you sell. Okay. Those are tough, and then you end up with kind of weak rights at the end of the day, because somebody can still generically refer to their product as the flavor of the juice is apple. So you're never going to be able to get a gag order on something like that. Okay, that's the wrong side of the line. Now the better side of the spectrum of distinctiveness, the first category is a suggestive trademark. And running with your Apple example, I'll say an apple a day keeps the doctor away in connection with vitamins. That would be a suggestive mark because it's a popular kids, or I don't know, what do you want to call that? But it's a popular little saying that people say, and it evokes imagery of medicine and doctors. But it requires a mental leap to get there, right? It's not like apple juice where it's immediately describing the quality. Apple a day keeps the doctor away. You got to think about it for a second, and then you get to vitamins. That's a suggestive trademark. That's going to be protectable as a trademark inherently. You don't have to show anything else. The final category is the one that you had mentioned, Apple in connection with the sale of computers. That's an arbitrary trademark. It's arbitrary because it's a real word that has no meaning in connection with the goods or services other than the brand equity that you build up. You only associate it with computers and phones now because Apple did a really good job of marketing and educating consumers about their brand. Those are the stronger marks. You want to be, the further you are, the further you are down this line of spectrum of distinctiveness, the better, from a trademark perspective. The other category that I would say arbitrary / fanciful, and that a fanciful term is one that is not a real dictionary word. It is like Google or Bluetooth. It's something that, entirely made up. Its only function is to be a trademark. So those are actually even a little better than an arbitrary trademark because they didn't exist prior to you. I mean, it means nothing other than your brand. So the further you can go down that spectrum of distinctiveness, the better from a branding standpoint. And where I would push and do push a lot of the startups that I work with is, go early, develop equity in the brand. You'll be better off in the long run. You'll spend less on trademarks in the long run, and you'll have bigger, broader rights. You can fence off more rights if you have a fanciful trademark because there's no need for your competitor to use anything close to what you have. So that's where I would do it. Having said that, obviously, I know I've been talking for a minute, but one other tidbit: if you're a startup, I'm not going to completely knock merely descriptive trademarks because there is value immediately. It's sort of a long-term versus a short-term benefit. The better long-term business plan is to pick a distinctive trademark, one far on this end of the spectrum, because that's going to give you the biggest rights in the long run. There is a short-term benefit, though, to that descriptive trademark because it immediately, you don't have to educate your consumers as much. If your product's called X1Y, XYZZZ, something crazy, you're gonna have to do a lot of explaining to what that means. Like, it's gonna take a lot of advertising. Whereas if your thing is apple juice and you sell apple juice, it's not gonna require a whole lot of mental exercise to get there. It's good in the short run, so it'll help you get off the ground quicker, but it's going to create problems for you down the line because you're not going to be able to fence that off likely, and you're going to have a hell of a time enforcing it. And you may even run into the trouble of third parties coming after you where, they think that they've got exclusive rights in that term and you're too close to them. And so now you're dealing with an infringement case. And, it's more sticky long-term.
Sure. Yeah, that makes sense. And on that, I saw on your website you deal with advertising, and that was something I haven't thought about, I guess, because it's not really directly related to what I do, but there was an example of like false advertising, and you mentioned earlier in your introduction as well that like you would be looking at a video if there's some brand mentioned, etc. So that, like, if I imagine from where I stand and my experience with branding and naming, so like somebody would come up with an idea, then you come up with names, then you go into domain names, so discussing some different, like you go to designers, and then the ongoing process of marketing in the company. And if I think about running an advert or just the day-to-day activities, marketing and sales activities in a company, at what point, like what's the red light, or at what point should a business owner say that I need to run it by a company like yours before it goes out?
Really, again, that's another one where it's like, ideally, like all of them, because there's so many ways that could go wrong. I mean, at a minimum, if you're just starting out, you probably want to do an initial consult with an attorney just to get your feet wet in terms of, and maybe have them look at like one or two of what you're doing. And then, maybe if you have a higher risk appetite or you just don't have the budget, maybe you say like, I'll just go with what I've got basically and try to stay within the right side of the line. But there's so many things that could, that's a very fact specific scenario where, tiny differences in the ad could make you fall on different sides of the line here. But again, if you're looking for like a general rule of thumb, we're worried about consumers again. And so you can't say anything that's false or misleading. and maybe that key emphasis on misleading. A lot of people know what false is, but maybe a lot of people, there's a little more wiggle room in terms of what's misleading. Pepsi couldn't say, if you drink Coke, it'll turn your hair blue. Well, assuming it doesn't actually turn your hair blue, it's, that's obviously false. But what if they said something, closer to, what if they suggested that it might turn your hair blue? I don't know. They ran an ad with people drinking Coca-Cola cans and all their hair were blue. I don't know. They did something that might mislead consumers about a fact, a material fact, something that might affect their purchasing decision. That would be false advertising. And so I guess you'd want to take a step back and try to be objective and look at your own advertisement and say, is there anything about this that is literally false? And if not, is there anything about it that suggests a fact that is false? That might trick some of my consumers into thinking something. And it's not necessarily about a competitor either. It could be about your own product. Drinking Pepsi will give you a 6-pack. No, it won't. Yeah, I would already have one if that were true. No, it's so you have to be not only careful about external brands, you got to be careful about what you're saying about your own brand too, and the representations you're making to customers. And it can be hard to do that sometimes. You want to take that's sort of the benefit of having counsel on those types of ads, because they're also an independent third party who doesn't have that emotional connection to your product that you likely do. If you're a startup, you're probably passionate about what you're doing, and you may not be as objective as you think you are about your product. And if you're going to say something about your product that it does X or does Y, then you really ought to be able to quantifiably back it up. You want to be able to support those statements. You can't make claims that your product is, kills 100% of germs. Well, did you do a study on it? Like, what study did you do? Does it actually kill 100%? Is it, only 100% of this type of germ, but really whatever it is, right? You have to be careful. You have to be careful.
If you're thinking like that all the time, it must be very hard being you watching ads.
Yeah, I know. I can't even watch the Super Bowl. I turn on all the lights in my house and close my eyes. No, I do. And it's fun too, seeing some of the ads that you've worked on and some of the brands that you've worked on, and you see something come out and you're like, oh, that could have been X. You can't say it because it's all attorney-client privilege, but I sort of chuckle and think to myself, like, that could have been, that was almost Z instead of X. That's a lot of fun.
So sounds like it. So it does very much, because in my head there was already like a little war in every in the bigger the companies, I guess the more complex it gets, because you have the people who come up with the ideas, then you have the designers who go, oh, we can do this, we can do that, and then you have the more technical side who go, no, you can't do that, or that's how you should do it, and now you just like added that perspective that I'm like, oh, okay, so now there's another somebody we need to ask. It almost makes me think that, I don't know if it's a done thing, but it probably is not a bad idea. Like if in a company you could have some sort of a even initially some crash course on the do's and don'ts on the legal side for everybody, because literally like a designer, a programmer, they don't even think in those terms, and that would be really helpful.
Yeah, I do actually some trainings on that. So, and I've done that a number of times where usually I'm talking to either a marketing team or an in-house legal team. So a lot of the bigger companies have attorneys, that work for the company that will be reviewing content, because they do, as you point out, as you're sitting there realizing that, like, man, I'm basically getting everything run through legal and checking, and that's kind of what has to happen. That's why a lot of these large companies have teams of attorneys who are just doing that, sifting through the content and making sure that it's okay, clearing the brands and making sure that it's okay. And even those attorneys, I'll sit down and do, maybe like an annual, like, reminder, here's a crash course on this is what trademarks are. This is what you're looking for in advertising. These are the new cases that came out. Be careful here. Be careful about rights of publicity. Make sure you're getting releases from everybody. And a lot of people want to use third-party content like videos from a social media platform or something of different users, and there's all sorts of nightmares there because they're generally things that are just happening live, right, with whatever the user is. They're not thinking about getting releases for the person who was across the room in that funny video, or they're not worried about that there was this brand in the background that was showing. They're not worried about the music that might be playing over top as they're creating that video. So there's just all sorts of but so to back it up, yes, a training session can go a really long way. And then for companies that don't have, that aren't quite as large and don't have that in-house lawyer or team of lawyers, I've also talked to them. It's a different presentation. It's more of the 3-year-old version of the status of the law and just sort of hitting the broad topics. You can't just go to Google Images and take that stuff and put it on your website. Like that's a no. Things like that. But they're tremendously helpful because it really is one of those areas of the law where an ounce of medicine is worth a pound of cure.
Yeah. No, I can absolutely see that. I mean, even just getting people to think in that direction and then asking themselves questions as they work on something is already a huge difference as opposed to I can take that image because it's on Google.
Right. So
so you mentioned on your website, I've done my homework going through your website, obviously. Your brand is one of your most valuable and essential assets, which I completely agree with, and I think it's even more present now than I guess ever before. And now, especially with the pandemic, that we have digital acceleration, everybody's talking about, everybody's online. And I'm going to obviously ask you about domain names. How and where do you see domain names as part of that brand? As an asset?
Yeah, I see it declining if I'm going to be level with you. When you say domain names, I'm really thinking of the big.com domain names. I see that, and I've seen that declining a little bit year after year. I think that the brands are obviously important, but the reason why the .coms are a little less important now, and I think you saw like a few years ago, you saw the burst of .ios because a lot of tech companies liked it because IO is short for input output, even though it's obviously Indonesia. But so and they could get short domains for what they were looking for. So they get a 4-letter dictionary word domain for $60 a year if it's a .io. And so a lot of companies flock to that. But anyway, I got off track. Where I see the change happening is that 10, 20 years ago, if you wanted hotels, what you might have done is you might have typed into a search engine or to a web browser, hotels.com, and hoping that you would find somebody who offers something about hotels. That was kind of how you found goods or services in the early age of the internet as a marketplace. But as time has gone on, I would say that most people, even when they type it into the search bar, they're actually running an internet query. They're running it on Google or the 5 people who use Bing or DuckDuckGo or whoever else, whatever it is that you're using, you're typing it into a browser likely, and that browser is likely running an internet search for the thing that it is that you're looking for. So I'm sure there still are some people who type in hotels.com, but I would venture to guess the vast majority of people who are looking for hotels search hotels as an internet search term on like Google, and then they see the top hits. And then they click the one that's been curated for them. And that may or may not be a domain name that has the word hotel in it. It could be a completely distinctive name. It doesn't have to be short. It doesn't have to be a dictionary word. What matters is getting ranked higher on page 1 or 2, really page 1 of internet search results. So as a result of that, I see the value of your dictionaryword.com domain names is decreasing, because the whole point is that it drove traffic. It drove traffic to the website because people were typing it in because they were looking for that particular good or service. They're not doing that anymore. Now it's about where you rank on the search. And if you're not ranking high, I don't care what your website's called, it's not worth that much anymore. So as time goes, if that's the way the market continues, and the people who are typing in hotels.com start to fade away, I see the .coms being less and less valuable. That's my take on the market direction, and I've seen that play out. I've seen over the last few years, I've had less and less interest in spending, less and less appetite to spend the money on the big .com domain name. They still do it. I still do it, but yeah. It's less than what it was. It's more, it's actually more important from a domain name acquisition point, as I'm learning, what is your current internet traffic like? Where do you currently rank SEO wise? Because that's what I want to know. That's more valuable to me than what the name is on the .com end.
I think definitely the reasoning and the perspective has changed. Yeah, like you said, rarely somebody types in the name and the .com. It's more, I think, as part of that integral brand image. So like if I'm Nike, for example, and I don't have Nike.com, I am going to be, whatever I do, I'm going to be losing emails and traffic and a bunch of other things and causing that confusion. And then I think there was an interview recently with Angel.com, I believe they acquired, and they were saying like we were wondering whether to spend that much money for a domain name. And then we calculated how much would it cost to get people to remember some alternative of that name, like getangel.com or something like that. So it's more that, and that's what I say to pretty much everybody I work with when people reach out for a particular domain name. It's about what is it worth to you. If you're just starting out, you don't obviously often times have six-figure budget for a domain name. And even if you have a six-figure budget and that's all you have, I wouldn't advise you to put it in that domain name. Yeah, that's one story. Yeah. But if you do have the budget and you do have that, really strong vision, idea, maybe even a product already, a good domain name that's exactly matching your brand name obviously can, propel you forward and save you. I think you mentioned earlier in the conversation, it's you mentioned it in not about domain names, but brand names. But there are certain names that are much easier to just be remembered by your audience, and that translates into cash, obviously.
Yeah, I completely agree. I mean, and I like the point that you were hitting on too about it's the domain name value is subjective, and it's a very unique marketplace because it's you can really engage in price discrimination in terms of the domain. It really does depend on the buyer. It's sort of like real estate, right? It's not unlike that. There's only one of this exact domain at this, top domain name. So if you want it, you can't, there's no alternative. If you're holding the .com, and you want that domain, there's no substitute other than changing the domain slightly. But if you wanted that exact iteration, there's no substitute good for it. And so it does allow, domain name registrants to engage in some intense price discrimination at times. If you know that the other side is a very large company, they may be willing and have been willing to drop a lot of money on it. But I think, in as you were pointing out, there are circumstances where that happens and where it makes sense. And I agree with that. But those are becoming more and more of the unicorn examples. And 99% of business isn't falling into that category. It makes more sense for them to pick up the get XYZ instead of XYZ.com, or to pick up a .io instead of the .com or .co or something else. and then just try to work on pushing that web page to the top of Google.
Yeah. And then we see, and it's a very common thing. We see a lot of upgrades, and it kind of works with that as well. Like if at some point you get to a point where you're large enough and big enough and it makes sense to invest in a better domain name, then then it makes sense.
Yeah, that's right.
Yeah.
But that pool of companies is a smaller and smaller pool, and so that I think it can be tough to be if you're holding a bunch of domain names. I think it can be tough because you're waiting for that one whale to come by and really be interested in one of the things that you happen to be holding. That can be tough. But it certainly happens, and then it's just one of those situations that when it pays, you may hold 1,000 domain names and pay hundreds or thousands of dollars, more likely, in registration fees a year. But then you get that one, and they pay $750,000 for it, and boom, it was worth it. Or you hold them forever, and if nobody ever buys them, it's a risky proposition these days. I think.
We mentioned it's like real estate. I guess it's very similar in many ways. It's effectively real estate on the internet, if you like. So yeah, it's a similar. I have that. There's that. It's dark behind me, but there's that apartment across the road that's like listed for sale for 10 million, and it's like the top floor, and they have a jacuzzi and everything. It's really cool, and it's empty, and it's not being used. But it's it's been there for like 3 years, and it's listed for 10 million, and it's I guess it's an investment, and that's very much how I see domains as well.
Yeah, they're not uncommon. Yeah, that's a good analogy. I think that's right.
Yeah,
and it's a good point. I think that, in fact, drilling deeper into that analogy, you're right. I mean, if it's a penthouse kind of apartment and it's got a jacuzzi and all sorts of bells and whistles. Yeah, those types of things maybe are worth holding on to, right? Because sooner or later, a big company probably is going to want to buy that very, or a wealthy person in this case, to keep with the analogy, is going to want to invest in that penthouse suite that's worth $10 million. Sooner or later, somebody is going to want that.
And that's the thing. I often say that to people as well. It really depends. Like I'm going to admit I don't have 10 million to spend on it, but even if I did. I wouldn't spend it on that. It's just not the sort of a thing that makes sense for me, not the sort of a thing I like, and not the sort of a way, I wouldn't know what to do with it. It's just not, if I was to buy it, I would have to, I don't like staying in one place for a long time. So I would have to think, okay, I need to buy it as an investment. How do I get my investment on that? How long is it going to take? It just doesn't make sense. But to somebody who has a way of either just enjoying it because they have it, or making more than 10 million with it, it makes sense.
Oh, yep. That makes perfect sense to me. So.
Yeah. And on rebrands, I wanted to ask you about something that everybody's talking about, like Facebook's rebrand now. What are your thoughts on that? Just because it's relevant and very timely.
Yeah, actually, I don't want to get into specific companies like that per se.
Oh, okay. No, it's totally okay.
Just generally though, thoughts about major rebrands. It's always a risk, right, to do that, because you've anytime you build up brand equity, you're jumping into something that is a little less known. You may not know the problems that are associated with that other name. There may be other companies that come out of the woodwork that claim better rights to that name, or that's confusingly similar to them. If it does cause consumer confusion in the marketplace, you're going to have to deal with that. It could be expensive from a legal perspective for you to do that, and then risky from a brand equity standpoint, because what if your consumers don't relate to the new brand in the same way that they did the other one? So I think it is anytime you have a major rebrand, it can be a risk. So I'll just leave it at that, I guess.
Yeah. Okay. That's very, a lot of people find, I've been talking about branding and rebranding with my last 3 guests, I think, on this, but they were in the rebranding business, the last 2 guests, sorry. they were helping companies rebrand, and I was expecting from them, since it's their job, obviously, I was expecting to them to be like, oh yeah, you should rebrand anytime, go ahead, and it's a good thing, and etc., etc. And actually both of them had a similar advice, more towards the risky part of it. So
yeah. Well, that's because there is some significant risk to doing that. But you have to imagine that all of that had been weighed, and
I'm sure.
Nobody makes that decision on a whim. kind of thing. So
woke up one morning.
Yeah, exactly. So that's it. Changing the company name. Just didn't like it today.
That's fun. Cool. Oh dear. All right, last question. It's not. What time is it there, by the way?
So for me, it is 1:18.
Oh, okay. So it's not late. It's just late here. Okay. Anyway, I'm not gonna hold you much longer.
Sure.
I see a lot of big names you've worked with, and you mentioned you oftentimes work with big companies. Just to give an idea of our audience, what sort of a company, what sort of a size, or how do you, like, if somebody wants to work with you, what sort of a company is that?
Yeah. Yes, you probably saw, it ranges. So from very, very large to very, very small. So there's really no size that would be inappropriate. It would just be the level of service that you would be looking for would be different. So maybe a larger company is going to be more interested in trademark maintenance, and they have 1,000 filings all over the world, and they need help making sure that they get renewed correctly, and just strategy about how to enforce those brands against other parties and how to defend those brands when demand letters come in. That's just a different type of discussion than a startup who, a startup, I'm telling right now, you need to be worried about not getting sued, and you need to be thinking about where you're going to rank SEO wise, and you need to be thinking about, what scope of rights could you get out of this trademark, best case scenario, 2 years from now, 5 years from now, 10 years from now. So it's the size of the company, there's really no, I'm indifferent, and I work with very big companies. I work with startups. It's just a different type of product, I guess, that you're getting. It just, I push you in different directions depending on what size you are to what suits your needs and is going to make sense for you to spend resources on. Like, if you're a startup, obviously the best thing to do is always to clear a trademark brand and to file trademark applications for your mark and the iterations of it, and to aggressively enforce those, and maybe not aggressively, but to make sure you're enforcing them, and to push those through to get registrations. But if you're a startup, you don't have the budget for that. Maybe even though you have 4 different brands potentially that should be protected, maybe we're just going for the house mark. And then maybe instead of doing it everywhere, maybe we're just doing it in 1 or 2 countries. Long story short, it just depends on. No wrong size for me, but you just, where I push, where you should go does depend on the size. That's the only thing that really truly changes.
Sure.
Yeah. And so I left just a little bit about that. I left a large international firm. I used to work for Cooley, and did the exact same thing that I do there. I do here now. And I just sort of saw a market gap, I think. I felt that large firm rates were maybe a bit too high for this type of work, and clients were sort of shying away from doing the types of things that maybe they ought to be doing in terms of protecting their brand or for getting trademark applications. Just the cost is just too high. So I kind of started this with the idea of doing trademarks right. Basically, I want to make sure that we're checking all the boxes that we're supposed to be checking. Not that we weren't doing it there, but it's just expensive to do it, and being able to do it in a way that's not going to crush your budget. So that was kind of the vision, and
your colleagues must love you.
No, I still talk to them. It's okay. Still talk to them. They're, it's it's when you're that size as they are, I don't think that it even blipped the radar. So.
Cool. No, I like that. Yeah.
Well, it was good chatting with you. I'm glad that we've been able to set this up, and happy that you had me on the podcast. Like I said, I love talking about trademarks and branding. It really is a passion of mine. So, and I can tell it's a passion of yours. I think I follow you on LinkedIn or somewhere else, and I see your post, and you can just sort of tell that when somebody cares about the brands,
yeah,
and
that's a side of what I'm doing that obviously I'm lacking expertise in. So it's really interesting and very helpful. And I think a lot of people that work in that space as well don't like they see that the legal side of it more as just a limitation. We can't do that because we have to check trademark, and let's just whatever. Or like you said, it's too expensive, and all of those things kind of add up to eventually you're gonna have to pay for it anyway. So yeah,
because you don't have a brand without the legals. I mean, you have to think what you might be thinking. You're holding this big bag of rights. You might be thinking, oh, I have this brand. And you really don't. If you don't have the title to it, you don't own it. And so, the brand is only as good as what the law says it is. And so you've got to be able to enforce it. So I think the legal side is just a tremendously important part of it. And unfortunately it can be frustrating for a lot of business owners because they think they're holding something that they're not. And I know a lot of them pass up on the legal side of it, thinking like, oh, just as you described, it's sort of like this nuisance and I don't want to deal with it. But at the end of the day, you don't have a brand if you don't have it. If you don't have it legally, you don't have it.
Yeah.
You know what I mean? So it's got to be careful with it.
Thank you for joining us in this episode of Smart Branding Podcast. Feel free to visit smartbranding.com for more information and reach out if you have any suggestions, questions, ideas, or just want to learn more about how a good domain name strategy can help you build a strong and successful brand. See you next time.